praise you, Lord. Yeah. Ha-ha. Oh, 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 oh. Everybody say, ah. Say, oh, oh. Say, how can I express my gratitude for all the many things you've done for me? Words are not enough to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things you've Father, you done for me, yeah. Words are not enough to say thank you. Say, Lord, you are, you're my everything. Say, I call you Zion. You're my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my
Hello there, lovely people. Thank you so very much. It's another Saturday afternoon with us here on BWTV, where we bring you the program, The Community and the Law. The second Saturday of the month of December 2023. Christmas is here and is dawned on us so very early live on the TV program, The Community and the Law. My name is Oreku Usufrimpon, and this afternoon the question I'm asking you is, how do the latest changes to the UK immigration rules affect you and your family? The answers next, right on BWTV and the program Community and the Law, brought to you by BWF Solicitors. Let's get into it together.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214-218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
And we are live. Hello, lovely people. Thank you very much. It's a wonderful Saturday afternoon here in London. A bit cold and, of course, chilly, rainy. But we are together to listen, learn, and also increase our depth of knowledge on immigration matters here in the UK and matters of the law also here in the UK and elsewhere. Once again, my name is Oreku Sufrimpon, and I welcome you to the program, The Community and the Law, that's going to run between now and 6 p.m. GMT. Now, this afternoon, we have a very interesting topic to give you. Just earlier in the week, the UK government announced changes to immigration rules. Now, the question I'm asking is, how do they affect me and my family? Or put yourself in there and ask yourself, how do they affect you and your family? Lawyer Charles Asma is my guest. Lawyer Charles Asma is a lawyer, where a solicitor, so to speak. Well, sometimes the difference is not too big, but he's a solicitor with BWF Solicitors. Lawyer Charles Asma this afternoon is going to help us unpick the various changes that have been made, and we look at each one of them and how it might affect you and your family. One of the things that really has been brought in is that dependents of skilled workers and migrants may not be allowed to come in. Is that what the law is saying? And if that is what it is saying, how does it apply to you and myself? If that's not what it is saying, what actually is saying? So we'll look at that. So let me first of all introduce my very lovely teacher, friend, and lawyer from BWF Solicitors, Lawyer Charles Asma. Uncle Charles, good afternoon.
Good afternoon, Brakoku.
Thank you very much for your time this afternoon. I'm always proud to say that whenever we knock on your doors, BWF Solicitors, you make time for us. So once we have you this Saturday afternoon, we are appreciative of that. And as I always say, I salute you and welcome you on to the show. How are you doing?
Very well, thank you. And we are grateful to God for the gift of life.
Good.
And the community is always looking forward to what BWF Solicitors has to offer in terms of empowerment, in terms of knowledge sharing, and making people independent to pursue their own social activities, including
Right.
immigration law and everything else. So, yes, we thank God.
Well, we thank God for small mercies, as my friend will always say. But let me tell you about BWF Solicitors. They are our trusted partners when it comes to the law. They have operated for over 30 years here in the UK. The principal and the senior partner, Uncle Ben, as we usually call him, has practiced for over 30 years. He practices here in the UK, practices in Ghana, and he knows a lot, and he has a lot of experience to share with us. Now, when it comes to family, he is a member of the UK family panel, so he knows the ins and outs of everything that talks about uh, marriage, divorce, and what it is that you can do immigration wise when it comes to family matters. Then again, we also have our immigration applications and rules and all the other updates that come in. He and his wonderful team have a wealth of experience that will help us so very much. So visit them, go to them. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. And if you would want to speak to them or book an appointment over the weekend, then definitely you have to call them and arrange that. They use the following numbers that we have on the screen: 0208 493 7340, 0208 493 7340, or the emergency number is 077 127 61884. Where do we locate them? We can find them on the fourth floor of the Anna House. Anna House is the building on top of the exit number 2 of Seven Sisters Victoria Line Station. 214 to 218, that's the address. London N15 4NP. You them, as I said, on 0208 493 7340. 0208 493 7340. BWF Solicitors are trusted partners when it comes to the law. And it is only appropriate that we say thank you to them. So let's take the message. And when we come back, I have some news for you.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate, or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
Yes, welcome back. Thank you very much for sticking and staying with us. Now, I said to you that I have news for you. Now, which month are we in? December, right? Okay. Now, last year we had a quiz competition, BWF Solicitors Customer Loyalty and Appreciation Quiz Competition, and we had a first prize of a return flight to Ghana, all expenses paid. Then we had a second prize of £200, a third prize of £100, and other consolation prizes. This year we're repeating the prizes because they are real good, and I need you to participate so you stand a chance of winning any of these wonderful prizes. First prize, return flight ticket to Ghana. Well, terms and conditions are in there, so they apply. The second prize is £200, and the third prize is a cash of £100 and other consolation. Now, these are the rules. Okay, you can call only once during the quiz competition period between now and the end of the month. 2, you can only have one attempt. Now, this year around, I have collaborated so very well with lawyer Charles Asma, and he has come up with some very thematic questions, very beautiful ones that will tickle your fancy, and very easy ones as well, don't worry. And so you can only have one attempt. In a minute, as many questions that you can answer, we will put the highest winner in the pot for us to have the draw before the end of the year. And then remember, the return flight is to Accra, no other area. It is to Accra. So if you want to travel to Paris, you want to travel to Amsterdam or any other city, no, the prize is for you to visit Ghana and to visit Accra. And definitely you'll be a guest of the BWF solicitor staff in Accra, because our office is also very open, waiting for you to visit. So these are the rules, and today we're starting the quiz competition. So at the tail end of the program, I'll be inviting you to call in. The number we use for our studio line, that is 0208 493 7345. 0208 493 7345. And remember, you can call only once. You have only one attempt for each question, and the person who can answer the highest number of questions within 1 minute wins for the day and will be put into the draw. Okay, good. Now, the other thing is, now let's get some information out there for you. So let's go to our nuggets, and we're looking at, for the past few weeks, we've been looking at employment issues, really. And one of the things that we have chanced upon, and as a question that's battling the minds of so many people, is about resignation. Now we say that, okay, I've resigned. Do you have to put it on paper? Can you just, out of or out of your mouth or in a conversation say to your employer or the person you are engaged with to say that, oh, I've resigned. You're not treating me well, so I don't want to work with you again. Can you verbally say that? Now let's look at a case we are bringing to you this afternoon. Omar versus Epping Forest District Citizen Advice, a 2023 case. England EAT is what? Um,
Employment
Employment
Appeals Tribunal.
Appeals Tribunal, and the case number is 132. Now, it says that employers must always consider the context of an employee's resignation before construing it as intended. If it is retracted, it must be seriously considered. And we say that the recipient of the resignation should, in the eyes of the reasonable bystander, consider that the resignation was seriously meant, really intended, or conscious and rational. The lawyers are coming with their big terms and the rest of it. But yeah, listen, we are lucky. Lawyer Charles Asma is here. He's going to break them down for us to really understand it. And the context for this case will also be brought out. Failure to consider the circumstances of the resignation may lead to unfair dismissal. There was this very interesting phrase that was used on television back in the day in Ghana when commentators were talking about football and commentating on football matches. Then there was one very popular man, Joe Latte. So the co-commentator will go on, rattle on and on and on. Then it says, over to you, Joe Latte. Over to you, Lawyer Asma. What are we talking about here?
Thank you very much, viewers and listeners. So today's nugget is on employment, and it has to do with dismissal and whether the dismissal is fair under the circumstance. Now, we know that there are two aspects of ending a contractual agreement. Either the employee or the worker will say, I want to leave, or the employer will say, I don't want you again. Either way, there is a starting point to the end of the agreement. Mm-hmm. So we are looking at when does it become okay and when it does not become okay in the eyes of the law. So we know that your employment contract will tell you when you can and what you have to do. When is any time you want to leave, and what you must do will be spelled out in your employment contract, what we call the terms of the agreement. Now, if the terms of the agreement state that you have to give notice, you have to give notice. If it is in writing, you have to have it in writing, and how long you do that. Again, there are instances where somebody may not necessarily put it into writing, but may say it, depending on the nature of the agreement. So the question today is, can I resign verbally? And will that be okay if the employer accepts it? And what happens if I change my mind, but the employer does not change his or her mind after accepting my verbal resignation? So we are looking at the context or the circumstance. The context is when the person or the employee or the worker decided that they want to leave, or they say, I have resigned. It might not be obvious that they will use the word resigned, but they may say, I want to leave, or I don't want to work here anymore. This is all part of the way to express whatever there is, the resignation. So this is verbal declaration of intent to not to continue to work for the employer. The case law we are looking at is a recent case law, 2023. And so it's very relevant, the case of Omar. What the court is saying is that there are two aspects to verbal resignation. The person giving the verbal resignation and the person accepting the verbal resignation. So we are looking at the action and the reaction. Action from the employee and reaction from the employer. If the employee says, I want to resign or have resigned, however they put it, the employer will respond yes or okay or all right, whichever way they also express it. But what if the employee changes his or her mind?
Mm-hmm.
What will be the reaction of that employer? Should the employer also react to the second action of the employee? Commonsensically, yes, they must also react. What if they don't react to the second action? Then it becomes a contextual analysis with a view to confirming whether refusal to react to the second action of the employee will breach the law or not. So what is the first action? The first action is that for whatever is happening, I have resigned in the heat of the moment. It could be misunderstanding, it could be whatever, but whatever it is, there is context, and the circumstance has made the person say verbally that they have resigned, or they don't want to work there anymore, or they are leaving. The employer accepts that if you want to leave, leave. If you want to leave, leave now. If you want to leave, that's fine. Whatever way they put it. Then the person comes back to say that I was only joking.
Mm-hmm.
You know, I can't go. Anyway, I'm here. Then the employer second reaction says that, well, you say you want to go, so go now. If the employer's reaction of not accepting the second action of the employee, which is the change of mind not to go, will that constitute unfair dismissal? Or would that constitute dismissal? The employer will argue that I was only sticking to my point or my position that you don't want to stay here, so go. But then, if that happens, it will appear as if the employer has premeditated and was waiting for the opportunity to say no. And therefore, given the opportunity, decided not to change his or her mind, even though the employee changed his or her mind by saying, I was only joking, or it is not the case. So we are looking at what an ordinary person on the street, what the law refers to as reasonable bystander, will say. So you're looking at the reasonable bystander test. Will a person who has enough knowledge about what has happened, understanding of what has happened, analyzing what has happened, conclude that the employer should have also reacted to say, I accept your apology and change of mind, or will say the employer should stick to the position and say no? A reasonable bystander will usually say the employer should have also been reasonable and flexible to also change his or her mind. And for you not to change your mind to accept the second action or react positively to the second action, you have not been reasonable. And if it is concluded that your action not to accept or react positively to the change of mind of the employee is construed to be unreasonable, then that resignation from the employee, though from the employee, your action has made it unfair dismissal. And if the person goes to court, the person is likely to win at employment tribunal. So if you look at the context, what are the key things? We have understood what the reasonable bystander approach will be.
Okay.
But would that reasonable bystander, with the full knowledge and understanding of the context or what has happened, conclude that the employee actually meant to resign? Is it possible that in the heat of the moment, anybody will behave like that? If it is so, then anybody in the shoe of the employer should also behave as such to change the mind of not accepting the resignation or telling the employee, yes, go. The second thing is, did the employee really intend to resign? Did the person, after working at the place for that period, be it 2 years, 3 years, or whatever, really in the heat of that 30-second argument or misunderstanding, take a decision to end the contractual agreement with all the ramifications or implications? A reasonable bystander may conclude that no, there is no realistic intention to resign, but for what happened. Would the reasonable bystander also conclude that the person was conscious of what they are getting themselves into in terms of resignation? In other words, did they think through properly? A reasonable bystander will conclude or may conclude that there was no conscious and rational decision to resign. And therefore, having changed his or her mind, the employer should also change his or her mind. And
Okay.
therefore, the tribunal is likely to go with the objective or reasonable bystander test and conclude that by refusing to accept the change of mind of the employee, your action has brought into being a dismissal which is not fair in the eyes of the law. That is the explanation or analysis of this nugget. Therefore, verbal resignation may not be resignation if it is not properly analyzed or taken into context.
So let me come to the ordinary person's parlance and say that I have a very reliable worker or member of staff who has threatened verbally to resign, or probably has even said to me that I'm going for the next month or so. You not see me again because you have not treated me fairly. Can myself, as the employer, say that I am refusing to accept your resignation? If I do say so, what are the implications?
Well, I think we've understood that employers must always consider, the word is consider, they must
Mhm,
always consider the context of the employee's resignation, what
mhm.
brought about the decision to resign.
Okay.
If it is in the heat of the moment, remember there's what we call self-defense and also subjective action. That subjective action, because it is coming as a result of that context, we have to look at it carefully to understand whether the person intended to carry out this action. Therefore, if the employer does not accept and does not carry out the contextual analysis of the circumstance and takes penchant view to this action of the employee, then it is likely that an employment tribunal will conclude that the action has not been fair in all circumstances.
Right. So verbal resignation may not be resignation, as Law has explained. Employer must always consider the context of an employee's resignation before construing it as intended. If it is retracted, it must be seriously considered. The recipient of the resignation should, in the eyes of the reasonable bystander, as Law has explained, consider that the resignation was seriously meant, really intended, or conscious and rational. Failure to consider the circumstances of the resignation may lead to unfair dismissal. Umar versus Epping Forest District Citizens Advice 2023 Employment Appeal Tribunal Case 132. And that's what Lawyer Charles Asma has talked about and he has explained. So let me ask you this question, which will be coming at the tail end of the program. There is a scenario that we have created that's going to really test your understanding of this concept that we have discussed. So let's get the quiz, tease you with that, then I'll come back. Kwesi Hothead resigned verbally during a heated exchange with his line manager. Kwesi subsequently sought to retract the resignation, but his employer disagreed and proceeded on the basis of a verbal resignation, bringing the employment to an end. Kwesi Hothead brought a claim to unfair dismissal at the employment tribunal. Now, question is, what is likely to be the outcome of the claim? Now, you in a verbal on an argument with your line manager, and you said, "No, I'm resigning. I'm going. I'm not working with you again." Then later on, hot head becomes a calm head, and he thinks that, um, well, I didn't have to say that, so obviously I want to retract that threat of resignation. But the manager says, no, 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 you can't. Your employment has been brought to an end because you said you were resigning. And Kwesi said, okay, let me go to the employment tribunal to test my case. They have dismissed me unfairly because I sought to withdraw my threat. Now, what's the likely outcome of the claim? The claim will fail because Kwesi offered his resignation and his employers accepted it. The claim will succeed because Kwesi retracted his resignation, which was made in the heat of anger. Then, three or C, the claim will succeed because the resignation was not in writing. Now, think about this at the tail end. We will do that, but we are going to get you excited. I told you in the month of December 2023, we're doing our customer and client appreciation quiz for working with us all throughout the year 2023. So the BWF Solicitors quiz comes up next. First prize, a return flight to Accra, and second prize, £200 cash, and the third prize, cash prize of £100 plus other consolation prizes. Now these are the rules. Watch. Only one call. So if you call today, you can't call again until the quiz is over. Two, now when you come on, within a minute, you have only one attempt. You can't say, oh, this question, can I repeat? No, I'm not going to repeat that. Then even during the program, you can call twice. You can only call once. Now the highest score of the day will be put in a draw, and that will be done later on in the year live on air. And remember, the return flight from UK is to Accra, no other city. It's to Accra. So watch that and let's get going. So if you're ready now, as I said, my partner in this quiz, so my PIQ is Lawyer Charles Asma, and our scoremaster and of course the coordinator is our studio director, Professor Adair. So the numbers we're going to use for the quiz, and if you are ready, just get your fingers going on, and it's 0208 493 7345. 0208 493 7345. So the next few minutes, we're going to, yeah, your timer is on the screen. Lovely, doubly. The next few moments, we're going to get the questions out, and we are going to get who will be on. 0208 493 7345. 0208 493 7345. I'm not accepting your WhatsApp calls. I'm not accepting your main texts. So call the studio number 0208 493 7345. Now, within a minute, you must answer as many questions as possible. So what we'll do is either myself or Lawyer Charles Asma will be reading the questions for you, and one of us will also be taking your scores, your names, and the marks. And so if you're ready, let's get it going. You're live on BWTV, and we're doing the BWF quiz competition, our customer loyalty and appreciation quiz that gets you waiting. A return ticket and all expenses paid, trip to Accra, and then the second prize is £200 a cash prize. Then the third one is £100 cash prize. Then other consolation prizes will come in. So let's get going. TikTok, the clock ticks away. Who is on my line? 0208 493 7345. Get going. Hello? Hello? Is somebody on the line?
No one yet.
Oh, no one yet. Oh, okay. I thought we had somebody on there. So, yes, let's get going. We've got a few minutes to do that before we go into our main discussion. Some very simple questions, all in 1 minute. Maybe, Lasma, I'm going to give it a try. Let's see how many I can answer in a minute. So if you can test me, can we get lawyer on the screen so lawyer can test me and see how many I can get in a So lawyer, no, you have your questions in front of you. Let's see how many I can answer before somebody comes in. I'm not
Right.
going to put myself in the price draw anyway. So let's see how many questions I can get.
Okay. How many days in the week begins with the letter W?
One.
Correct for 10 points.
No, no, hold on. Prof, can you put a timer on there? So the questions, you keep on going until my 1 minute is over. Then we can say how many I got correct. So let's get going.
How many days in the week begin with letter S?
One. Two.
How many ethnic minority prime ministers has Britain had in recent times?
Three.
Time is nearly there. But just so you know,
Yes.
because this is law, we have to be clear with the terms of the
Okay.
offer. One of
Okay.
the terms of the offer is that the flight to and fro is much as it is specific destination, it is also for a specific period, window
Okay.
of season, so peak time. So that's something that we have to be mindful of.
Mindful of.
Yes.
Okay.
And the next one, yeah, so we have our rug. Oh gosh, the time is up. The
Well,
time
my
is
time
up.
is up, unfortunately. Well, that's the way it's going to go. Well, viewers, listeners, that's the way it's going to go. So we will put a timer on there. You'll see it on the screen. So if your minute is up, definitely you will know that your timer is up. So you won't tell me that you didn't time it properly. I'll put the timing on the screen. So let's get going. 0208 493 7345. Anybody coming on there? We got a few more minutes then we can go on to our discussion. But in the meantime, let me say thank you to BWF Solicitors, our proud sponsors who have always supported us to bring you live on BWTV, the Community and the Law, every Saturday afternoon between 4 and 6 p.m. BWF Solicitors is located on the
I think
fourth
you go
floor of
to
the other house,
reception.
214 to 218 Tottenham High Road, Seven Sisters. Call them on 0208 493 7340 for any immigration issue, for any matter of a law interpretation, and of course, all the updates that we need to give you. BWF Solicitors is your trusted source. Monday to Friday between 9:30 in the morning and 6 p.m. Then you can get them. The emergency number is 077 I think I've got somebody on the line because I'm hearing that signal there. Hello?
I think the person couldn't wait, so please do that
Oh
again.
boy. Oh boy. Can you please try again and we get you going? Because the prize is there to be won. A return ticket to Accra off peak, as our lawyer has explained, terms and conditions definitely apply. The second prize is £200 cash. Third prize is £100 cash, and other consolation prizes are available for you to win. So call in now 0208 493 7345. Come answer as many questions in a minute. And if you are the highest scorer in the program for the day, then definitely you will be put in the draw and we'll be having a few weeks of that. Then definitely we will have the live draw. So, if we don't have anybody, we'll take a break, then we'll come back to our discussion. We'll come to the quiz again after our discussion before we draw the curtains down. So let's say thank you to BWF Solicitors and we'll be right back.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Welcome back, and thank you for sticking around. Somebody, somebody just texted me to say, "Well, Bompa, you didn't get all the answers correct." Well, lawyer Charles Asma didn't mark me, so I wouldn't know how many of them I got wrong or right, but I got my score here. You come in. I'm a quiz master, and of course, my partner in quiz is lawyer Charles Asma, and I will be taking you through that. You stand a chance of winning the prizes that are stake. But in the meantime, oh, okay. Let's get going. Hello. Oh boy. Why are you guys not staying on the line for me? What's happening to you? Right. Okay. Now let's get into our discussion. We'll come back to the quiz. Those of you who want to call, please hold on to that. We'll come back to the quiz. Let's get into our discussion. We've got 15 minutes to the very top of the hour, 15 minutes to 5 o'clock here in the UK, and we are coming to have a discussion. But earlier on, there was an announcement that was made here in the UK concerning immigration matters and issues, and it was saying that UK government announced that care workers can no longer bring their dependents, including spouses and children. Care firms that want to sponsor people for visa applications will need to be regulated by the Care Quality Commission. In addition, the family visa financial maintenance requirement is expected to be raised from 18,600 to 38,700
Hello,
to ensure
Binoso.
only bring dependents whom they can support financially. Now,
Hello.
is forming the basis of my discussion this afternoon. And I want us to look at these new updates. Well, updates are new anyway. These are new things that have been brought in the guidelines and the rules, and also to
We have a
see
caller.
the affect us. Hence, our topic for today. Our topic for today says that the new rules and regulations as per immigration, how do they affect me and my family? Um,
We have a caller.
Here there's a caller on the line. So let me quickly get that quiz bit done, and
Hello.
use it a few minutes. I think
You are
the
still
line.
there. Good.
Let's get to the quiz. Hello, hello.
Yes. Hello.
Yes. Good afternoon.
Good afternoon. Wow, I can hear you for 1,000 miles away.
Well, I'm 1,000 miles away from you, so you are right. Can I have your name,
Yeah,
please?
but can you hear me all right?
Very, very well and clearly. Can I have your name, please?
Oh, okay. Your line is very, very faint.
Your full name, please.
Yeah.
What's your full name?
It's Ofe Christy.
Ofei
Ofei.
Kwesi.
Yeah.
Kwesi. Kwesi.
Yeah. ASI.
Okay. And OWFEI.
Yeah.
Thank you, Ofei. All right. So I'll pass you over.
Okay, Ofei. Lawyer Charles Asma is going to read out the questions. I'm going to do the timing, but you see the timing on the screen, so don't you worry too much about that. I'll be scoring, so whatever you get right, we'll see how many you can get right
I think
in 1 minute. So if you are ready, Lawyer Charles Asma will read out the questions for you. Are you ready?
I think I don't know if I have to because I'm struggling to hear.
Can you
I'm trying
hear?
to hear. I can hear you, but
That's the more reason
can't
he is going to read
hear
out the question, so
Uweku.
don't worry.
All right. Okay. So if you can hear me, do
Yes.
listen to me from the studios.
You said
So
I should listen to you
yes,
from the
listen to.
studio.
I'm going to ask you the questions, and Oreku will take the timing and
Okay.
check how
So
many you get right.
just before
Oh,
you go on,
okay.
Hold on, please, Sophie.
okay, you don't
Yes.
have to, if you don't know the answer, go on, because he's going to ask as many questions as he can in 1 minute, and you have to answer all of them.
Okay. So when I don't know the answer, what do I say? Pass.
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 Yes.
Oh, okay.
Okay. So, Prof, can we have the timing on the screen? And it starts now. Go.
Okay, Sophie, your first question. Call questions about BWF Solicitors. In which year was BWF Solicitors established?
Ooh, I know it's in the ooh, pass.
The senior partner of BWF Solicitors first qualified as a lawyer in Germany. True or false?
Can you repeat that again, please?
The senior partner
Yes.
of BWF Solicitors first qualified as a lawyer in Germany. True or false?
False.
How many partners has BWF Solicitors?
About 5.
Name 2 practice areas of BWF Solicitors.
Immigration, family.
Which of the areas of law does BWF Solicitors not practice? So you listen and choose the odd ones. Which of the following areas of law? Oh, time is up. So, Afar, your time is up. Well done for participating. You cannot dial in again. You give chance to other people, but you have one question correctly answered.
Oh, okay. Okay,
Okay.
thank you. But
All right, Afe, thank you very much, and we appreciate your time. You have gotten
right.
yourself into the competition. Let's see if any other person can come in and answer more than one. Then the person would
Okay,
have
thank
displaced
you.
you. But
Bye.
if the person doesn't answer more than one, you are the highest on the day. So thank you very much. We'll move on to another person. If we can have another person on the line now, 0208-493-7345. 0208-493-7345. Do we have anybody on the line? If not, I will want us to look at the latest changes to the immigration rules in the UK. The government has announced that care workers can no longer bring their dependents, including spouses and children. Another thing is care firms that want to sponsor people for visa applications will need to be regulated by the Care Quality Commission. That's another thing. The third one is here, and it says that the family visa or financial or maintenance requirement is expected to be raised from 18,600 to 38,700 to ensure people only bring dependents whom they can support financially. Lawyer, when new things come in, when changes come in, sometimes those of us who are not lawyers, those of us at the other side, we often panic and say, well, the chances that we have are being blocked. They're making things more difficult for us. They don't want us to do X, Y, Z, or they want us to do X, Y, Z because of 1, 2, 3, 4 reasons. These are changes and things that have been announced. Can you please take us through them?
Thank you very much. So, viewers and listeners, once again, good afternoon. Pleasure coming your way from the studios of BWF Solicitors. So, today's conversation is about the changes that have taken place over the last week or two and impact on us and our families. So, we have the key changes on the board. Prior to the ones we have on the board, we had the changes about students, which took place far back in July, October. And we know that for students, they cannot bring their dependents, that's children and spouses, from January 2024. And the exact day will be the 16th day of January. What it means is that if you're a student and you want your family to join you from abroad, you have to apply before 16th of January 2024. Now, apart from students, we also have the recent changes, and we know that it borders on people who have entered the UK as skilled workers, also about the companies who intend to recruit people from abroad or employ people from abroad to come in as skilled workers, and it also to do with everybody who is making application to bring a family member to the UK. So the first thing is to do with, let's start with the employers or the
Mm-hmm.
potential employers. If you are a care provider, let's say you have a care home and you intend to recruit from abroad, what the law now is that you have to be first regulated. And the regulator of such service is the Care Quality Commission. So if you
Mm-hmm.
are not regulated, you cannot employ people from abroad to pursue this activity. And therefore, care delivery or care service has become a regulated activity as far as immigration provisions are concerned. And
Yeah, let
therefore,
me ask, if you don't mind, let me ask a quick question here. Now, the Care Quality Commission, were they not regulating the practice already? Or they didn't really have to exert themselves? They are not doing that because of things that are happening?
so there were, but there were flexibilities.
Okay,
So there were companies that have not necessarily gone through or been through the CQC approval processes, but they
okay,
were delivering their caregiving service in the UK.
okay,
And because the need for the service was apparent, government was flexible. But
okay,
now it's been rated a strictly regulated activity. And therefore, you cannot seek to bring somebody from abroad, or you cannot even seek to recruit somebody from within the UK to perform this regulated activity if you have not registered with the regulator or the approval of the regulator has not been sought yet. So these are
okay,
the changes. That means before you can even do anything as a care provider, you must have CQC approval to do the work or to do that, to perform that service in the first place.
okay. We can go through the various changes that have coming. Then, when we get to the point where it affects me, myself and my family, some of the questions I'll bring forward. So let's move on
Sure.
with that.
Right. So the next change, so you see that with this change, if you are seeking employment from an employer, you have to ask yourself whether the employer is regulated by CQC. If the
Okay,
employer is not regulated by CQC, you are putting yourself at risk as potential employee.
okay,
The next thing is you, the employer, must ensure that you've gone through the CQC approval process to gain the accreditation from the CQC before you can approach the Secretary of State or the Home Office for license to practice. Or if you have already been given license before you even move on to apply for COS. What it means is that if you're a care provider, check. If you haven't gone through or sought approval from CQC, you have to take steps to regularize that process. So that
okay,
is to do with the employers. Now we come to the workers. So you are in the UK or you will be coming to the UK to work for that employer. Once you've gone through the process of recruitment and selection and you have been successful, you will be issued with what we call the certificate of sponsorship to enable you apply for visa to remain in the UK to work for this new employer or to come from abroad to work for this employer.
okay,
Either two, the law was flexible and therefore you could bring your family members, i.e., your spouses or spouse, of course, one person at a time. So your
okay,
spouse and your children. But from spring of 2024, the new change suggests that you cannot bring your spouse or your children from abroad. And sure, even if they are in the UK and you have switched and you now want to integrate them, it will equally be difficult if you don't do it before that date. We know it's spring. However, anything can happen. And therefore, if you ever intend to bring your spouses and children to join you in the UK as a skilled worker, please do it now. Do it now before it's too late. Because it's like we can wake up after the new year, January, and we'll be told that they have brought the date forward from spring to new year. So if you have anything to do, the time is now. What happens after that date? After that date, you cannot. What it means is that only the migrant can ever come to the UK to work for that employer. So what does this law simply mean? It simply means that if you are coming to work, you don't need the moral support from your family members. They can stay where they are and you work. And if you want to go on holiday to look to visit them, you can do that. But they cannot migrate to join you. So it's very important that we take note and act now. The next change we know is to do with if you are applying to bring your family from abroad, especially your spouse. The change is to do with spouse. It did not touch children. The bit about family migration is your ability to maintain yourself and your spouse. So until the laws are fully changed in spring, we know that if you have employment and you work, earn something, you have a threshold of 18,600 to show as your gross income. And that will allow you to get your spouse to join you. In other words, you can prove that you can look after yourself and your spouse. Unfortunately, the new provision in the immigration rules suggests that you have to add 20,100 to the 18,600 to make 38,700. So it's a very huge change, more than 100% increase in the amount of income you should have to be able to bring your spouse from abroad. What do you do? It means that if you ever want to bring your spouse from abroad and your income is 18,600, make sure that you do that before the law becomes effective. If you don't do that, you have to then make sure that your salary is up to 18,000, 38,700, 38,700. Whether you are working for yourself or working for somebody else, you must show 38,700 gross salary. And if you are working for yourself, 38,700 profit after all your expenses are paid. So you pay tax on 38,700. What if you don't? Then you have to wait till you are earning enough in terms of profit before you can make an application for your spouse to join you. And this is a very huge change. We hope the government will listen to the call to review. However, we have to act and act fast.
Well, ladies and gentlemen, our brothers and sisters, as you heard Lawyer Charles Asma explain, the three main changes that are being announced are the ones we have looked at. We have spoken about the organizations that are seeking to employ people into the care sector would have to now be regulated by the CQC, that is the Care Quality Commission. Then again, if you are seeking to bring your partner from spring 2024, it may not be possible. And I will have a few questions around that. Then the financial and maintenance requirement is now from 18,600 gross to 38,700 gross. And if you're self employed, after you have deducted all your expenses and other incidences, you would have to earn or you have to have 38,700. These are major changes. Then the question is, how do they affect me? How do they affect my family? And what needs to be done? Now, for the regulation lawyer, I asked the question: does it really affect um, the employment criteria? For instance, somebody has to pass the English language IELTS at a certain level. They would have to uh, get the police reference check done, their TV tests, and all the other bits. Now, being regulated by the CQC, are these affected? Would they have to have any changes at all? Or the CQC would now have to decide that this person can be employed, that person cannot be employed? Is that what it means?
So the CQC um, consideration is to do with the employer, whether they are the right employer to be able to be given the clearance to
Okay,
recruit into care work,
okay,
either
okay,
recruit people from abroad or recruit people from within the UK. The CQC is just checking to see that people are doing the right thing and protecting and mitigating risks to do with care provision.
right,
Once you are regulated by CQC, it means all the necessary things that you have to do in terms of compliance, safeguarding, protection, and so on and so forth are all covered. And therefore, the government is confident that you are doing the right thing. In terms of the employee coming from abroad or from within the UK, they
mhm,
still have to show English language proficiency. So that is
okay,
not taken away or
right,
reviewed. They also have to show that in terms of safeguarding, if they are coming to work in care, they have police clearance. And if
okay,
it is in the UK, they have DBS done. And that is also not changed. So those two are not changed. The third one, of course, is the certificate of sponsorship, which can only be issued if the employer passes the CQC regulation or assessment test in terms of whether they are registered with CQC or not. And also, let me chip in this whilst we are on this point. We're also telling them prospective employees to be very mindful because there has been instances where the course or the certificate of sponsorship might have been issued multiple times. But because you are not able to tell whether it's been issued multiple times with the same number, you are only putting yourself at risk. So if you are dealing with an employer, make sure that, and that is the reason why they want employers to be regulated, or each employer must be compulsorily regulated by CQC, so that these things can be avoided. However, if you are seeking employment and you are giving COS, make sure that you've done your due diligence and you know that the COS is genuine. If it's not, you put yourself at risk because then it is picked up and you are banned from entering the UK for 10 years, and you have to go through the process to have it reviewed. Quite uncomfortable experience and time consuming and costly. So let's be mindful of that. In terms
well,
of the employer,
yes.
in
Yeah,
terms of
I
the
was going to
employer,
come on that. That what happens to the employer if these things are found out?
I mean, in terms of the employer, we don't know what the government will tell them to do. But if the employer is actually regulated and genuine, then we'll assume that that incident will not occur. Because no genuine employer will issue multiple COS to people. So that
Okay.
is the response to that. But the employers
Mhm.
must show that there's genuine vacancy, genuine employment. In other words, the hours are available to the effect that when the person arrives, they will have job to do. So if the employer is not able to prove that, or you, the applicant, are not able to prove that, on the balance of probability, it is high that they will tell you that the job is not available and therefore visa will not be granted to you. So again, make sure that the job is there. Don't just seek to enter the UK, but make sure that the job is available. Otherwise, you may not get a visa at all to be able to enter the UK. These days, when the employers are seeking to be issued or granted um, COS
Mhm.
increment, or they have already and they are asking for more, they ask them to show that the hours are available for the number of people they are seeking to recruit. If they are asking for license for the first time, they are asked to show that there is a need for the license, i.e., what is the business justification for seeking to employ people from abroad? How many hours do you have? How many people do you have already? Are those people already using taking up the hours that you have? If there is extra hours for which you are seeking to employ people through the request for license or COS, um, are those hours enough? So if somebody has, let's say, 100 hours and they are asking for um, license to be able to recruit, the question is, do they already have someone employed? Let's assume that they've employed two people and they're already working 37.5 hours. That is 74, 75 hours already. 75 hours from 100 hours, 25 hours left. The question is, if you are seeking to get a license to be able to recruit to fill 25 hours left, is that sustainable? Is that reasonable?
Mm.
And are you recruiting to give somebody half, I mean, part-time job? Because 25 hours is part-time job. So those are the questions that the caseworker will be asking, and will ask you to justify why you should be given license to recruit to fill 25 hours vacancy. Why can't you get it in the UK from somebody who may not require you to give them sponsorship?
Mhm.
And therefore, you have to ensure that the contract is in place from the client, from the service contract partners that you have agreement with. And the contract suggests that the hours are enough every week so that you can be trusted with recruiting from within the UK or abroad.
Now, lawyer, the CQC is coming to regulate more closely now. The regulation kind of, or the new change is starting from January right into through to spring 2024. What about those who have already issued out cause? Potentially those who are having issues and people are complaining about. Are they going to regulate retrospectively or they're not?
What the government is saying is that if you're a care provider, you must register with CQC.
Okay.
So you need your CQC certificate or number to show that you are under CQC. If you are not
Mhm.
under CQC, it's likely that when you are going for renewal of your license, it may not be successful. Because now it's compulsory that you have to be regulated, or you should have registered with CQC.
Okay. Right. So if somebody reports that, um, I'm still about the same question, but in another way because people have been expressing that. If somebody reports that I was giving a certificate of sponsorship in March 2023, which is a few months back. Now, the person is not going by the terms of the contract that they made me sign. Can I appeal to the CQC or make a complaint to the CQC to say that company X is not adhering to the rules, or I may have to report to the Home Office instead?
CQC is not supposed to check whether you have a job or not.
Okay.
CQC is only checking to ensure that you are compliant with care provision um, regulations and statutory processes.
Mhm.
So ensuring that we have policies and procedures in place to safeguard the people we look after, i.e., the service users. So if you
Okay.
don't have CQC approval or processes in place, what it simply means is that you are likely to go scot-free, or you are likely to commit certain offenses or do things that may not be picked up. And that is why it's now compulsory that every care provider must go under CQC.
Okay.
CQC, whether you have a job or not, is not what they are looking at. Home Office will now check to see whether you have a job for which you are seeking to renew your license or seeking to have more certificates of sponsorships issued. Now, if you, the employee, having arrived in the UK and realizing that the employer does not have job for you, it's a matter for you to have a conversation with that employer. Unfortunately, if they don't have a job, it might be that they have lost a contract or the hours have all been used up before. The Home Office will look at your potential hours and grant you certificate of sponsorship. Now they are looking at actual hours. So whatever
Okay.
has happened before the change is already there. Nothing can be done. That is why there's now rigorous processes in place to ensure that all those companies that are not able to comply are weeded out of the system. So it's a matter for the Home Office, not the CQC.
Okay. Now, my next question is the one of the changes that's going to happen is where people cannot bring in their partners. I have a big issue with that in the sense that we when we're talking about um, integrating people into the community. Family support and network is very vital. Now, you're telling the person that you can bring in your partner, you can bring in your dependent, you can bring in X, Y, Z. Is it not breaking that human right aspect of the law?
It's a public policy consideration. Yes,
Okay.
families are being teared apart or separated, and that may have consequence. However, it's a choice for the family members where they want to stay together, and the rules that pertains to their migration ought to be adhered to. It's a matter of, do I live in my home country so that my family member comes to join me in my home country, or I come to join my family member in that foreign country? What are the things I need to have in place before I do that? So much as the new law or the rule is punitive and harsh, it's also a case of people preparing themselves to the point that it should not be detrimental to the general public. I think in terms of wider policy considerations, the government position is that we have a number of people entering the UK, and that is having effect or a toll on public services. But there's also the argument that families should not be teared apart. And so, where do we draw the line between public good and family cohesion. Where there is a choice, people will be given opportunity to make a choice, whether to meet the rules and come or wait till they have met the rules. I think that's what's going to happen now.
Now, let me look at it from this point as well. So previously, before this new change, there was the kind of blanket provision that once you've been given a contract, say 5 years, 10 years, whatever, you can get your partner or your dependent to enjoy the same facilities that have been given you as the person who has signed a contract. But now they are saying that it is not blanket, but you have to go by the immigration rules. Is that what it is saying?
Well, it's always been the case that we have to go by the immigration rules.
Okay.
Just that the bar has been raised
Raised.
so that instead of 18,600, you are now looking for 20,100 more to add to the trouble you're already facing getting the 18,600.
Okay.
What it means is that if you are able to show that you earn 38,700,
Mhm.
if you pay your tax and you pay your national insurance, all the deductions out, you still have more than 18,600 more so that you'll be able to fend for yourself and those family members who are joining you so that there wouldn't be any burden on yourself to the effect that the burden will be transferred to the state. And that is the policy dimension for this change.
Right. So the 18,600 has been increased to 38,700 is to, maybe for lack of a better expression, weed out the people who are unduly taking advantage of the situation.
So there is a policy on immigration, and the government wants to make sure that there is objective view to immigration policy so that immigration does not become a burden, much as it is a benefit. So people coming to the UK will be allowed to enter the UK. However, they must be prepared to show that they can fend for themselves. And we know that you have to show that you can fend for yourself. Once your family member has arrived, that duty is no longer there until they are going to renew the visa or the leave. So we can say that the duty to show 38,700 is for the or at the point where you are applying for entry clearance or applying for leave to remain as a partner. After that, once you are granted, there's no law to continue to show anything. But whenever you are making such application, you must show it.
So the regulations, the new bits of that have come up as we have been discussing. Care organizations would have to be regulated by the CQCs, that is Care Quality Control, and the Care Quality Control Commission. Okay, and then the partner thing. If you want to bring your dependent, you would have to meet the finance requirement, which has risen from 18,600 to 38,700. Now let's look at, as earlier on BWF Solicitors made us to know the summary of some of the changes that have been made, these latest changes. Now, UK government has announced that care workers can no longer bring their dependents, including spouses and children, Care firms that want to sponsor people for visa applications will need to be regulated by the Care Quality Commission. And in addition, the family visa financial or maintenance requirement is expected to be raised from 18,600 to 38,700 to ensure people only bring dependents who they can support financially. Laura, let me look at the third bit, which is the financial maintenance requirement that is expected to be raised to 38,700. And the very first one that says that care workers can no longer bring their dependents, including spouses and children. It looks like there's a caveat here that, yes, like in a blanket situation, you can't. But if you want to bring in, this is what is going to happen. Are there any exceptions? Or do these two paragraphs really go to complement each other? Can you unpick it for us?
Which, so the first paragraph you mean, or the second paragraph?
Yeah, the first paragraph. UK government has announced that care workers can no longer bring their dependents, including spouses and children. Then the third one says, in addition, the family visa financial maintenance requirement is expected to be raised. Um, how do the two go together? Do they complement each other, or one stands off the other?
Yeah, so they are independent paragraphs. So the first line is the preamble to all the others. Just that the first line appears to be part of the first part. So the UK government has announced one, that care workers can no longer bring their dependents. Two, care firms that want to sponsor people for visa applications will need to be regulated by Care Quality Commission. Three, family visa financial maintenance requirement is now up from 18,600 to 38,700. So these are the three blocks. But the first line is just a preamble, just that it's only added to the first paragraph, suggesting that it's only for that one and the last one, no. So they are independent.
Somebody has just sent a text, and let me just throw it in here and ask that: is it closed totally that people cannot, or care workers can no longer bring in, but there may be exceptions or situations where you could bring in, but under certain conditions? The person wants a clarification on that.
So what they are saying is, or what the law is saying is that up to the point where there is a change, that's spring 2024, people who are entering the UK to work for employers under appendix skilled worker provision to the immigration rules can bring their family members. Because if you are traveling, leaving your family behind with all the potential risks and consequences, if you have a choice to come with them, it's better for the family. Family
Mhm.
cohesion, family support, emotional support, physical support, and all aspects of support. So if you are coming with your spouse and with your children, it's allowed. However, there's going to be a change, and the change will start from spring 2024. And therefore, from that time, any application made by a dependent of a skilled migrant, be it spouse or child, will not be valid because the law might have changed by then. So what this is actually telling us is that we are all put on notice that if there is anything to do in terms of bringing family to either come with us or join us later, we have to do it before that time. And I think it's a fair approach by the government to put people on notice so that those who intend to do it can do it. And if you don't do it, then it's a choice you have.
If you just joined us, you are with us on the Community and the Law on BWTV, brought to you by BWF Solicitors, our trusted partners when it comes to the law. BWF Solicitors has got a bunch amount of years of experience behind them to help us, one, understand the law, two, how to go about dealing with issues of the law, and three, when it comes to our applications and legal support, BWF Solicitors does it better than any other else. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. You call them and you book an appointment. The number is 0208 493 7340, 0208 493 7340, or the emergency number 077 127 61884, 077 127 61884. Now, if you want to meet any of the lawyers, there are two partners and other lawyers within the organization. If you want to meet them outside of the Monday to Friday window, then you have to book an appointment and arrange for the weekend for them to meet you in the office. And remember, they are on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London, 0208 493 7340. Let's take their message, and when we come back, we'll pick up your questions and your concerns. Lawyer Charles Asma, our resource person for today, is here, and he'll be gracious enough to answer all of them. It could be about a topic we are discussing this afternoon, the new immigration changes and the way they affect you and your family is what it is. But if you have any other question, you can drop it in, and the resource person as Lawyer Charles Asma will do justice to that. It's the Community and the Law Live on BWTV. We'll be right back.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate, or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the interstate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
Welcome back. The UK government has announced that the changes to the care route will be happening between January and spring 2024. Care workers, so to speak, can no longer bring their dependents, including spouses and children. Care firms that want to sponsor people for visa applications will need to be regulated by the Care Quality Commission. And in addition, the family visa financial maintenance requirement is expected to be raised from 18,600 to 38,700 to ensure people only bring dependents who they can support financially. Earlier on, we spoke about verbal resignation. You would realize that for the past few weeks, we've been talking a lot about employment, your rights, the things you need to really know, the technicalities and things like that. Now, verbal resignation is what we discussed earlier today, and it may not be resignation. Why is it so? Employers, so to speak, must always consider the context of an employee's resignation before construing it as intended. If it is retracted, it must be seriously considered. The recipient of the resignation should, in the eyes of the reasonable bystander, consider that the resignation was seriously meant, really intended, or conscious and rational. Failure to consider the circumstances of the resignation may lead to unfair dismissal. This is based on the case Omar versus Epping Forest District Citizens Advice. It's a 2023 case, the Employment Appeals Tribunal case number 132. And there is a question that I want you to test your knowledge with, and that is about this Kwesi hothead who resigned verbally during a heated exchange with his line manager. Kwesi apparently thought about the whole thing and said, I probably may have spoken too quickly. So he wanted to retract the resignation, but his employer disagreed and proceeded on the basis of verbal resignation, bringing unemployment that Kwesi had to an end. Kwesi Hothead brought a claim for unfair dismissal and employment tribunal. Then the question I'm asking is, what is likely to be the outcome of the claim? It will fail because Kwesi offered his resignation and his employers accepted it. Yes, you say you work again, so okay, we also say yes, we will employ you again. Is that unfair? No, I don't know. So you tell me. The claim will succeed because Kwesi retracted his resignation. It was made, which was made in the heat of anger. Right, you said it. So, well, would that be the basis for the claim being successful or not? The third one is the claim will succeed because the resignation was not in writing. Think through all these things, and when I come to the curtain drawing down situation and the segment of the program, I'll be asking you to give me answers. But in the meantime, if you have any question you want to put to Lawyer Charles Asma, you can call in 0208 493 7345 or send a text to 073 or send a WhatsApp message, voice note, or any form of message on WhatsApp to 07950422 My resource person, my guest this afternoon is Lawyer Charles Asma from BWF Solicitors. Uncle Charles, we've looked at what needs to be done, registration and being overseen by CQC. Partners and dependents cannot be brought in. The financial regulation and the financial maintenance is raised from 18,600 to 38,700. Just a brief summary of all these things, then we can pick up some questions and concerns from the platforms.
Thank you very much. So we have understood that the government has made changes to the existing provisions, and they come into effect in the spring of 2024. We know that the changes are in four folds. Before this, we were aware that students dependents cannot join their partner students or their family member who is studying in the UK if they are not pursuing a PhD or a research-based master programs. And this will start from 16th of January 2024. What it means is that students, dependents seeking to join them in the UK can apply from now up until 15th of January 2024. However, with the work side of things, the job-related skilled worker, there are employer side and the employee side. Then we have the general family migration provision that has changed for finance. So if you are a care provider, you have to make sure that you register with Care Quality Commission, CQC, so that your activity is fully regulated. Does it mean the activities were not fully regulated? They were fully regulated, but there were flexibilities. And then the government is saying that every care provider must be regulated. So it's now law. If you're not regulated by CQC, then you cannot deliver care service. And if you can't deliver care service, you cannot recruit people to help you deliver that service. So that's the starting point. The next point is to do with the care workers or the skilled migrants in the UK. It says skilled migrants. What it means is that those people who are already here and want their family members to join them, you have to apply for them to join you before spring 2024. What if you do not? They will not be able to join you on that ticket. They can through other routes, but they can't based on how you entered. So if there is the need for anybody to take action, it has to be on the basis that they may not be able to, or they will not be able to, from the point the law is changed spring 2024. Is it likely that it will be brought forward? It is likely, and therefore, if you want to act, you have to act now. In terms of income threshold, the law does not say that if you are dependent of a skilled worker, you have to show maintenance of 38,700. That provision applies to those who are applying for their spouses to join them in the UK because they are British citizens or people settled in the UK with indefinite leave to remain, or EU nationals who are living in the UK with pre-settled or settled. So if you're a care worker or you're a skilled worker and you want your family to join you, the maintenance threshold will be the one that is spelled out under appendix skilled worker provision. If the employer has said that maintenance is covered for you and your dependents, then you do not have any duty to show maintenance. If the employer has not said that, then you must show by way of providing bank statement. However, that is only the amount specified under the provision. 38,700 is only for British citizens or people who are foreigners but have indefinite leave to remain in the UK, or people who are EU nationals with pre-settled or settled status in the UK and wishing or seeking to bring family to the UK. If I say family, spouses. But we do know that if you are a EU national, you do not have any duty under the law to prove maintenance. It means that this maintenance change or financial threshold change is for British citizens or people who have indefinite leave to remain non-EU who want to bring spouses to the UK.
Well, that's a summary of the kind of information we have churned out today. So, if you have any question, as I said, the numbers on the screen are 0208493745 and also text 07399208468. WhatsApp only 0795042278. There's a question here. The format and content, is it the same? Is it responding to which? Is it different? UKVI is just to show the provider is approved for. Your question is not too clear. The person who sent it. Well, if you can help us with that. Lawyer, what's the difference between IELTS general training and IELTS UKVI general training? Can I apply the care worker visa with both exams?
No, you have to apply with general training UKVI. So UKVI general training. Because the other general training will be for other things. But with the skilled worker, it has to be UKVI approved general training.
Okay. Yes, you can also post your question and concerns in the comment section either on Facebook or YouTube or the other social media platforms, apart from the telephone numbers we have given you. So you can call in as well, 020-8493-7345. Now, this person is saying that I have been given accommodation by my council due to DV reasons. Now, later on, the HMRC has written to me that I have no recourse to public funds on my status. Therefore, I wasn't entitled to the housing benefit they gave me, and they are asking me to pay back. Is that correct?
Can you repeat for us, please?
Um, I was given accommodation by my local authority for DV purposes. Later on, HMRC is asking me to pay back because I have no recourse to public funds on my status. Are they correct?
HMRC is asking you to pay what back? Is it the rent of the
The rent,
accommodation?
the rent.
HMRC? I'm not, well, HMRC will usually not ask you to pay back rent.
Okay.
It was to do with tax or national insurance or anything like that.
Right.
So,
So if the person was enjoying, say, universal credit, which nowadays would include the tax benefits, would they be right in asking the person to pay back?
so it might be that it's not HMRC, but DWP.
Okay.
Um, so the pensions department, works on pensions. So let's say job center. So if
Okay.
they're asking you to pay back, what it means is that they think, as you said, you do not have recourse to public fund. But if you went through domestic violence process and your application was approved for recourse to public fund, then that exemption would have been given to you. But there are people who would not have the exemption or would not seek the exemption, but they will still go ahead to apply for the status or the leave to remain under CDV. So it depends on how the person went about it. If you were genuinely in hardship and you applied and you were given the concession, then you are right. But if you didn't go through the process before applying for the help, then you will be wrong.
So in this case, a person in this situation obviously distressed and went into that situation, and it could be, for purposes of our discussion, it could be that somebody who was handling the case within the local authority thought that the person needed that help and may have advised that go ahead and put this through and we will grant it for you because you need help and it was desperate. In that case, how does the person defend themselves?
So we will have to look at the circumstance, how the person applied, the response from them, and all the representations or the point, the things the person said to them as part of the application process to get the help. Then we'll put together and make a representation to the agency in terms of the job center, telling them that this is the situation and this is how it happened, and therefore, under the circumstance, they may have to waive it. But until we are clear about the fact, the full context, we'll not be able to offer advice. If the person wishes to pursue this, he or she may contact us.
Yes, we're still taking your concerns. Lawyer, I have applied for divorce and it's taking more than 6 months for me to get a response. Can I write to them to ask them to expedite action because I'll need to get out of that situation as quickly as possible?
These days, the process takes place online. So it might be that they have not received a response from the respondent, if this person is the applicant. So they have to follow to see whether the other party has responded to the um, acknowledgement document sent to them or response document sent to them by the court.
Hmm.
Otherwise, they can ring the court and ask what is happening.
But do they actually tolerate that? That you keep badging them to say you are delaying my situation, so please hurry up. Are they okay with that? Can anybody
The
do that?
delay could be as a result of something. If the delay is as a result of your partner not responding to your application, then you cannot attribute the delay to the court. So
Okay.
if you call the court, they will tell you what the delay is about. If the delay is as a result of administrative processes, then you only have to have patience. But if it's a case of from your own side or from your partner's side, then you'll be aware and know what you have to do to um, escalate the process or to continue the process.
Okay. If you have any concern, if you have any questions you want to put to lawyer, let's have it. Now, please, has the salary threshold increased for care workers if you're coming from overseas?
If you are coming from overseas, so we have we have employers or some employment that require that you are paid within certain threshold. Obviously, it will be above the minimum wage or at the minimum wage level. So we do know that the government, as part of the processes, is requiring that employers pay above the minimum wage. So within the shortage occupation framework, care providers were given opportunity to recruit, and in terms of salary range, some were offering 20,000, 21,000, and above. But with the processes and with the changes, the government is proposing that most of these care providers pay their workers above the minimum wage. So employers are aware and they are taking steps to revise that or review that. So your COS will tell how much you have to be paid. And the employer, before requesting or issuing the COS, knows the salary threshold and will have to ensure that they put the right threshold on that.
The other bit is can I ask that my employer gives me a certain level of salary so I'm able to meet the threshold that will allow me to bring in my dependent?
So in terms of the family, in terms of the 38,000 or
Yes,
38,000.
38,700.
So if you can ask the question again.
What I mean is, if I'm negotiating, can I insist that my employer gives me a contract that covers the threshold that allow me to bring in my family, because I want my family to join me for the duration of the contract, say it's 3 years, 5 years, because you would not want to tear apart your family.
Well, if you are negotiating, of course, you negotiate for the best. It's
Mhm.
not that you are telling the employer that I'm bringing my family, so make sure you give me 38,700 at least. Well, what if the skill set is not up to that? So it
Right.
depends on the role, the responsibility attached to the role, and that will warrant the salary threshold for that position. So the question should be, do you have what it takes to apply for a job that pays 38,700 or more? If yes, go for it.
BWF Solicitors helps us with all our legal issues and matters. They help us put in our applications. They explain the laws and the new things that will come when they are introduced. If there are any things that need to be done, BWF Solicitors is able to help us. And the purpose of this whole program is to, one, educate us as to what the laws are, empower us to understand it, and also use the laws and the guidelines to our good benefit. Then again, also to help us integrate very well in the community. It's about law, about immigration, wills and probate, and all the other legal issues. They are experts. I've got two messages for you. When we come back, we do our quiz and we draw the curtains down. We'll be right back.
Cool.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the interstate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
Hello, yes, good afternoon. You are through to the studios.
Yeah, good afternoon. I'm Lawyer.
Your name and where you're calling from, please.
Yeah, my name is Emmanuel. I'm just calling to inquire regarding to the new immigration rules that are coming. You see, I want to be very clear. In case I'm just applying for my indefinite leave to remain, I recently just got wages just increased and then met the 18,600. Now I got through the 10 years route and then I'm now applying for the indefinite leave to remain. Please, since I'm not meeting, I just met the 18,600. Does it mean if I am going to apply for the indefinite leave and I will not meet the 38,700? It means I can't make my application. Is that what might happen to me, please?
But your 10-year route leave was based on your child, I suppose, or even your part year. So this has nothing to do with your type of visa leave.
Oh.
Okay, so it's for those who have to sponsor their wives or husbands, and they have to show the 18,600 before, which is now going to change. So you don't have to worry about that when you are due for your.
Thank you very much.
You're welcome.
Okay, so I think we will go to our quiz again. So Lawyer, maybe you'll be on standby to explain to us what the answer might be. The nuggets that we brought in and the question that we posed, verbal resignation thing that we talked about, employers must always consider the context of an employee's resignation. So the question we asked was this. Kwesi Hothead, in a heated argument with the line manager, threatened to and said, well, he said, I've resigned. So the manager said, okay, I've accepted it. But Kwesi thought about it again and decided to say, well, I am withdrawing the resignation. The employer said, no, you have said it and we have accepted it. He brought a claim for unfair dismissal at the employment tribunal. So what will be the likely outcome? So drop in your answers and let's go on with it. Will the claim fail? Will the claim succeed? A says the claim will fail because Kwesi offered his resignation and employers accepted it. B, the claim will succeed because Kwesi retracted his resignation, which was made in the heat of anger. And C, the claim will succeed because the resignation was not in writing. There's an answer, there's an explanation to the answer, but let me see your trial of it. How would you answer this one? Is it A, B, or C? Drop that in. And in the meantime, let me also remind you that our client loyalty and appreciation quiz has started. Today, we only had Kwesi Ofe, who answered one correctly. In fact, he answered two correctly, but the first one that he answered correctly, he asked that we repeated the question for him. And we said that one of the rules is that it will be answered once and will be said to you once. So we didn't give that to him. So he had one correct. Well, Ruth Atia says the answer is C. The claim will succeed because the resignation was not in writing. Ademununkum also brings in to say the claim will succeed because the resignation was not in writing. Tiliduma says C because the resignation was not in writing. Erajua says C. The resignation was not in writing. Well, let's look at the other two answers. The claim will fail because Kwesi offered his resignation and the employers accepted it. The claim will succeed because Kwesi retracted his resignation, which was made in the heat of anger. Well, we have just about a minute more for you to drop in any answers. We have Ruth, Ade, Tilly, Rajwa. Emmanuel Sechi also says the answer is C. Emmanuel Sechi always watches us on YouTube. So you will be the class captain on YouTube, Eddie. Buddy. The claim will succeed because the resignation was not in writing. Lasma, everybody is saying a C because the resignation was not in writing. That's what they say. Is that correct?
Okay, right. So verbal resignation and the circumstance. We know that um, the uh, the employee Kwesi acted and acted again. So the first action was to say, "I will have resigned." And once he resigned, he changed his mind. So if he has changed his mind, the question is, could the employer also have changed his mind to accept his change of mind? The position is that the employer should also be fair to accept that and to change mind. So to err is human, to forgive is divine. Did the employee err? Did the employee err? Yes. Did the employer forgive? No. And because of that, by not forgiving and sticking to your position to say that you have resigned and so be it, you have not been fair. So the claim is only going to succeed because the employee Kwesi retracted the resignation, which was made in the heat of anger, and therefore the employer should have reconsidered and also accepted. And therefore, on that basis, an innocent bystander will conclude that there has been unfair dismissal.
Well, the respondents that say that the answer is C. If we could go back to the question and we read the C answer, the claim will succeed because the resignation was not in writing. Could that not hold some water?
Well, the question says that when so Kwesi resigned. If you go back to the nugget, the original nugget, the
Yeah.
context, then we see the difference between B and C.
Okay.
Employers must always consider the context of an employee's resignation before construing what the resignation actually means. What it means is that people can resign verbally because the contract was itself verbal.
Okay.
So if I was employed verbally, I can only resign verbally. But even if I
Okay.
was employed with all the terms and I resign verbally and my employer accepts that, so be it. So what we are saying is that resignation can take any form or shape, but
Okay.
it is the context that matters. And if the employee change their mind, having verbally resigned, then the employer must also be circumspect to forgive and to take them back.
Okay. So people were kind of deceived with the resignation not being written. Words of dismissal or resignation, or words that potentially constitute words of dismissal or resignation, must be construed objectively in all the circumstances of the case in accordance with the normal rules of contractual interpretation. There's a quote here that says the subjective uncommunicated intention of the speaking party is not relevant. The subjective understanding of the recipient is relevant. That's why lawyer kept on looking at and hammering the point of the bystander, and there's an understanding of that. And remember, this is a case of Aruma versus Epping Forest District Citizen Advice 2023 Employment Appeals Tribunal, case number 132. Now, remember, Monday, another nugget will be coming out your way, so watch for that in the social media space. And the quiz question would be thrown out, yes, for you to kind of try your hands on that. So when we come up on Saturday, you can give us your correct answer, and the explanation to the answer being correct will be given as has been done today. And also remember, our quiz has started, our Christmas quiz has started, and we would want you to participate in that. Is our client loyalty and appreciation quiz. What we are offering, BWF Solicitors is offering, is a first prize, which is a return flight to Ghana, fully paid for. Now, the condition is that you have to have travel within the off-peak period. Yeah. The second prize is a cash prize of what, £200. The third prize is £100, and there are other consolation prizes. Now, the rules are clear and simple. You can call only once during the quiz period, and any particular time that we have it on air. You would have only one attempt. So if you say repeat the question, yes, we'll repeat the question, but you get it wrong. And during the quiz period, for instance, today you can call twice. The highest score of the day will be put in a draw that will be done live on air. Then finally, remember, the return flight is to Accra, not any other city. Now, today we have Kwesi Ofe, who had won. And yes, fortunately for Kwesi, you are the highest scorer for today because nobody contested you. Isn't that nice and real? Okay, so remember, last year we have a winner going to Accra, and we caught up with him on the flight. We will be giving you that detail. And of course, when he comes back, he would want to tell us his experience and show his appreciation to BWF Solicitors as well. So remember, Thursday on the legal education program, Friday on the legal education program, we'll be repeating our quiz, and then we'll have another one on Saturday, the 16th of December 2023. With that, I go, and I will not break tradition. I'll ask Lawyer Charles Asma for a minute to just summarize what the latest changes to the immigration rules are and how they affect me and my family for us before we say our thank yous.
Cool. So just so viewers and listeners are aware, because when we are going through the quiz questions, we did not tell what the answers were, but we knew that the caller answered some of them correct. So the first question was, in which year was BWF Solicitors established? The answer is 2006. That's what we wanted. The next question was, the senior partner of BWF Solicitors first qualified as a lawyer in Germany, and the answer is false. First qualified as a lawyer in Ghana. And then last one we asked before the time was up was, how many partners has BWF Solicitors? And the answer is 2.
So, time and tide, they say, waits for no man. We can never be exceptions to this wonderful and general rule. We have been discussing, as Lawyer Charles Asma, resource person from BWF Solicitors, and by their kind courtesy, we have looked at latest changes to the immigration rules and how they affect myself and my family. If you have any other further question, you can call BWF Solicitors on 0208-493-7340, 0208-493-7340. Or you can also speak to Lawyer Charles Asma. Let me get you his number again, 079 okay, 07947636037, 07947636037. Or you can call the BWF Solicitors emergency number 077-127-6180, 884. Lawyer Asma, thank you very much. Uncle Ben, thank you. Lawyer Eunice, thank you. Auntie Cynthia, and all the other lawyers of BWF Solicitors and staff of BWF Solicitors front desk and back end, both here in the UK and back in Ghana. I want to say thank you so very much for your support and encouragement and the work you do behind the scenes. And to Sheila Ankara and Pat Mododu for doing the aesthetics and the admin work, and to my producer and manager of the show, Professor Adair, for your unflinching support and your hard work. Thank you so very much. My name is Oreku Frimpon, and to you out there, thank you so very much for your time. We'll be back again with you same time next week. And remember, the quiz is on. Stand a chance of winning the flight ticket to Accra. Participate. Let's get on together. Have a good evening.